right, older workers could soon find it easier to prove age discrimination. Happened yesterday regarding the House Education Labor Committee with a vote, big one. And here to talk about it is leading labor attorney Jonathan Bell, the Bell Law Group, of course. And you always welcome back to the airwaves right here on LA News Radio. John, how are you?
I'm doing good, Jay. How you doing?
Oh, I thought this was a big piece of news with a vote yesterday to approve the protecting of the elderly, older workers against discrimination. It's called the POWDA. That's the Protecting Older Workers Against Discrimination Act, introduced by Senators Chuck Grassley, a Republican, by the way, from Iowa, and Bob Casey, a Democrat. Good to see they're working together here from Pennsylvania. So we know the vote coming in pretty good shape here as the number of older workers, John, kind of rises, right?
Yeah, this is long overdue. The burden for proving an age discrimination case is different than proving race, religion, and gender cases. So this kind of evens the playing field, and I'm a big supporter of it. It is, like you said, getting some bipartisan support. So let's hopefully see this thing through.
And it has been a point of contention for many, John, as far as age is concerned. But basically, ladies and gentlemen, this bill would make proving age discrimination a little bit easier by allowing workers to kind of prove their age. That was a factor in an employee's decision to discipline. Could be maybe firing him or not even hire them. Not the sole reason, right, John?
Yeah, so this is the major difference. To prove an age, a race case or religion or gender case, essentially you have to show that there was some motive in discrimination. For age cases, however, you have to show that it's the primary or decisive motive. So basically, the way that the Supreme Court ruled in the past in 2009, that if you were unable to show that age was a decisive motive, then you lost your case, which basically allows employers to discriminate against people because of their age. As long as they have another reason for doing it, then someone can't prove their case against us. So it really sends the wrong message to employers. So this bill will essentially overrule a 2009 Supreme Court decision.
Right, and that was big back in 2009, and that required workers to prove that their age was the main factor in any type of decision there. I know I read the case of Jack Gross there, John, suing a financial services company. He claimed the company violated the act. I think it was in the late 60s, which when it demoted him, at least in part because of his age. I think he was 54 at the time, and the court ruled that while Jack Gross was able to show that age was one factor in his employer's decision, he actually failed to show that it was the sole reason. So, to me, listen, if anything else, folks, it sends a decision, right, John, that employers that, advocates say the decision sent a message to employers that some age discrimination was fine. So, in essence, they got to think twice now.
Yeah, I mean, realistically, these older workers do need protections. 76% of people 45 years or older say age is a major obstacle in obtaining employment. 25% of people over 45 have said that they've undergone negative statements related to their age in the workplace. 40% of people say that they plan on working over 66 years old. So there's a good reason to have this law in place and established because people need these types of protections. Realistically, in 1991, that's when the bill passed that expanded the Civil Rights Act of 1964 that allowed mixed motive to be proven as discrimination, but left out the Age Discrimination Act of 1967. So it's a good thing that if this bill passes to kind of equal the playing field. These older people in the workplace, they need the same protections as everybody else.
Talking with John Bell, leading labor attorney, Bell Law and Associates. John, what about, I kind of correlate things sometimes to the sports world. And when let's say an NFL team is looking to hire a head coach, it's called the Rooney Rule, in which they have to be able to offer interviews to those in the minority. What about something like this? Is it going to be hard to prove in some cases, where you have an individual who might be up for a position, mid to upper 50s, a lot of younger folks maybe coming down the line. What about that aspect of it? Is it going to take a lot of time in the courts to make decisions regarding possible discrimination in that regard?
Yeah, it definitely will. I mean, litigation in general could take 3, 4, or 5 years. And, this bill doesn't make age discrimination easy by any stretch. I mean, you still have to prove things through circumstantial evidence. There's very rarely any direct evidence of discrimination. No one's going to come out and state that they didn't select somebody because of their age, or they're being fired or demoted because of their age. They never give the reason. So these cases are never very easy to prove. You basically have to look for comparator information. The person who got the job, the person who was promoted, what are the characteristics of them? And then you have to show that you are obviously more qualified than that person for the position. So, I mean, the beauty of this law now is you could just show that age was one of the factors they considered when they really shouldn't have considered it, as opposed to the decisive factor. So that's really the significance of this. I can tell you right away, discrimination cases are probably one of the most challenging cases to prove. And even though we have a great track record of it because we know how to prove those types of cases, they are challenging. They don't settle until the very end. And something like this is like I said, is very long overdue. I don't know why the law in the past has treated age different, which sounds discriminatory in itself. The law actually treated age differently than these other protected classes. I mean, if I make a decision based on one of my employees and part of the reason is age or part of the reason is race, I should be liable for damages because it's illegal under the Civil Rights Act of 1964, as well as the Age Discrimination and Employment Act of 1967.
100%. John Bell with us, leading labor attorney. I mean, let's face it. Listen, it's good this thing came out. It's going to shed more light on it. But I agree with you on all fronts. It's going to be hard to prove. It's just a matter of who goes the distance here into the courts. You look at elderly folks, not even that elderly, somebody in their 50s who has the experience in a position. You'll have how many times it happens all the time where you have an employer not willing to pay for that experience, kind of going for somebody a little bit younger, maybe kind of trading them their way, paying them a lot less. That's going to factor into things. Very tough to prove, John.
Right. Yeah, and a couple other things. I mean, the way that Facebook used to run their advertising for employees, you could actually send ads out to younger employees and exclude older employees from even seeing the ads. And just another point I'd like to make. I think this is the first time you've ever said that you agree with me on all fronts. So I think that's important to show the bipartisan nature that kind of everyone's getting behind. Now, the truth is, hopefully this won't lose steam just because it's ignored. It really shouldn't. I think this is important as the working class gets older. People are living longer. They have to plan for that. They feel younger. They feel like they could work more. So we need these protections. We can't just always look for the millennials and the younger people. We have to do what's right for the job, which is looking at experience and how you could take someone to the next level as opposed to just making presumptions based upon someone's age.
No question. And let's face it, they're working longer. They have to. All the folks, they're going into their 70s right now, to 80 years of age. They can't retire. Too much going on in our world right now. The cost and everything, especially you live on the island, forget it. You're working a lot longer, and you have to be sharp. Let's face it. If anything, it's a message, and that discrimination in the workplace because of age is not acceptable. Bottom line, good message. It's going to take some time as far as getting to the courts, and as you say, it's not cut and dry, John Bell.
That's right. It's not cut and dry. I imagine that this will at least allow people to feel like they can be successful in the court, because showing something is the sole factor or only factor is very, very complicated, because it gives the employer an out too easily that they could come up with some other motivating factor. Could you imagine an admission in court saying, yeah, maybe age was a factor, but also this other thing was a factor, and the court saying, well, because there's another factor here, I don't really see that there's age discrimination, or you can't be successful in your case, even though an employer made an admission that age was part of the issue. So really, I mean, it was a poor decision back in the day in that Gross case. So I'm glad to see that that this bill will correct that terrible position.
Yeah, and think about the jobs that'll be added to the economy over the next few years by folks over age 55. You know, that's going to be impressive as well. We'll keep an eye on that. John, always a pleasure. Yes, you are right. This is a first for us. We kind of agree. Well done, of course, John Bell, one of the best as far as labor and employment attorneys out there, and the owner, of course, of the great Bell Law Group. We'll talk soon, sir. How's that?
Great. Thanks for having me on again. I appreciate it.